We'll take it out from there, and we follow in the order in which we introduced ourselves earlier. That the Constitution of Kenya 2010 is a transformative one has never been in dispute at all. Its implementation has, however, not been without considerable challenges, mainly because of competing interests among three categories of Kenyans: the holders of political power, aspirants for political power, and the majority of Kenyans who are apolitical and whose foremost interest is to see that all the affairs of this country are well handled, irrespective of who rules political power. The Constitution declares that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with the Constitution. The people of Kenya have delegated their sovereign power to Parliament and legislative assemblies in the county governments, the national executive and the executive structures in the county governments, and the judiciary and the independent tribunals. The judiciary has been given constitutional mandate to arbitrate political, social, and economic disputes among the people or among the three arms of government. It is required to do so by way of diligent and honest interpretation and application of the Constitution and the laws of the country. These appeals are basically about the interpretation of three articles of the Constitution, 255, 256, and 257, that form Chapter 16 of the Constitution. The appeals arise from the judgment of the High Court sitting in Nairobi, dated 13th of May 2021, in Constitutional Petition number E282 of 2020, consolidated with 7 other constitutional petitions, numbers 397 of 2020, E400 of 2020, E401 of 2020, E402 of 2020, E416 of 2020, E426 of 2020, and 2 of 2021. Each of the petitioners challenged various aspects of the Constitution of Kenya Amendment Bill 2021, hereinafter the Amendment Bill, and the process that preceded the crafting of the bill. The background is as follows. On 9th of March 2018, President Uhuru Kenyatta and the former Prime Minister Raila Odinga, who had come out of a bruising presidential election contest, decided to bury their political differences that were evidently causing considerable discord in Kenya and came together with the aim of uniting the country. In a symbolic handshake, the two leaders set in motion various events that were aimed at moving the country forward. The President and the former Prime Minister released a joint communique known as Building Bridges to a New Kenya Nation. The communique contained 9 issues that affected our country, and these are ethnic antagonism and competition, lack of national ethos, inclusivity, devolution, divisive elections, safety and security, corruption, shared prosperity and responsibilities, and rights of citizens. In order to address the identified issues, on 31st of May 2018, the President, by Gazette Notice number 5154 of 2018, appointed the Building Bridges to Unity Advisory Task Force, the BBI Task Force thereafter, to document and recommend practical policy and administrative reform processes that would build the country's lasting unity and the implementation modalities for each identified challenge areas. The terms of reference of the BBI task force were as follows. A, evaluate the national challenges outlined in the joint communique of BBI to a new Kenyan nation, and having done so, make practical recommendations and reform proposals that build lasting unity. B, outline the policy, administrative reform proposals, and implementation modalities for each identified challenge areas. And C, conduct consultations with citizens, the faith-based sector, cultural leaders, the private sector, and experts at both the county and national levels. The BBI task force visited all the counties in Kenya and collected views from more than 7,000 citizens from different ethnic groups, community leaders, religious institutions, to name just but a few. On 26th of November 2019, the BBI released its report on what is known as, quote, building bridges to a united Kenya from a nation of blood ties to a nation of ideals. In short, it's referred to as the BBI Task Force report. On the following day, the report was unveiled to the public, and the public public engagement thereon kicked off. The BBI Task Force report came up with various policy and administrative reform recommendations which enabled constitutional amendments, policy reforms, statutory enactments, institutional reforms, as well as behavioral and ethical changes amongst the citizens. To actualize their foresaid recommendations, the President, by Gazette Notice number 264, dated 3rd January 2020, and published in a special issue of the Kenya Gazette dated 10th of January 2020, appointed a steering committee known as the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report. The mandate of the steering committee was twofold. Number one, conduct validation of the BBI Task Force report through consultations with citizens, civil society, faith-based organizations, cultural leaders, the private sector, and experts. And two, propose administrative, policy, statutory, or constitutional changes that may be necessary for the implementation of the recommendations contained in the BBI Task Force report, taking into account any relevant contributions made during the validation period. The BBI Steering Committee held a number of stakeholder consultation meetings and received memoranda from members of the public and organizations, and on 21st of October 2020 presented its report known as the Report of the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report. The report recommended various constitutional, legislative, policy, and administrative measures. The BBI Steering Committee also came up with a draft Constitution of Kenya Amendment Bill 2020. The recommendations made by the BBI Steering Committee and the draft Constitution of Kenya Amendment Bill 2020 were viewed by various stakeholders and members of the public as unconstitutional for various reasons that I will highlight hereafter. To accommodate those concerns, some amendments to the draft bill were made, and the final Constitution of Kenya Amendment Bill 2020 was printed by the government printer on 25th of November 2020. The aforesaid amendments did not stop various petitioners from moving the High Court in 8 petitions to challenge the process by which the amendment bill was formulated and the contents thereof. They argued that they were unconstitutional. The following petitions were instituted. Number 1, petition number 2, E282 of 2020, David D. and others versus the Attorney General and others. 3 main issues were raised in this petition, namely, A, whether the legal and judicial doctrine of the basic structure of a constitution, the doctrines of constitutional entrenchment clauses, and amendable constitutional provisions, and constitutional amendments the theory of unamendability of the Constitution, essential features in our Constitution, and the implied limitations of the amendment power in our Constitution are applicable in the Republic of Kenya. B, whether Chapter 1 on sovereignty of the people and the supremacy of the Constitution, Chapter 2 on the Republic, Chapter 4 on the Bill of Rights, Chapter 9 on the Executive, and Chapter 10 on the Judiciary, and the provisions therein form part of the basic structure, entrenchment clauses, and eternity provisions of the Constitution, and therefore cannot be amended either under Article 256 by Parliament or through popular initiative under Article 257 of the Constitution. And C, whether taking guidance from the doctrine of the basic structure of the Constitution, the constituent power, and the doctrines of unconstitutional constitutional amendments, the limits of the amendment power in the Constitution, and the theory of unamendability of the eternity clauses, there is an implied or implicit limitation to powers of constitutional amendments under Articles 256 and 257 of the Constitution. Dr. Duncan Oburu Ojwang, Dr. John Osogo Ambani, Dr. Linda Andisi Musumba, and Dr. Jack Busalile Mwimali, law professors, were admitted as amici curiae, and they advanced similar arguments as the petitioners in petition number E282 of 2020 regarding the basic structure doctrine, the limits of the constituent's power, and the role of the courts in interpretation of the Constitution, among others. Number 2, petition number 3E397 of 2020, Kenya National Union of Nurses versus Steering Committee of BBI and others. The petitioner urged the court to determine whether the task force on building bridges to Unity Advisory Committee was duty-bound to include an independent and constitutional health service commission in its October 2020 report. The petitioner sought 3 orders. 1, a declaration that the omission of the petitioner's proposal for an independent and constitutional health service commission in the October 2020 report of the task force on building bridges to Unity Advisory offends Articles 10, 27, 41, 43, and 47 of the Constitution of Kenya, and the task force on building bridges Unity Advisory be compelled to publish a fresh amendment bill to include the same. B, a declaration that the IEBC be prohibited from conducting the preparatory process towards the approval of the amendment bill and submission of the same to a referendum. C, an order that Parliament be restrained from receiving and passing the amendment bill. The third petition was E400 of 2020, Third Way Alliance Kenya versus Steering Committee of BBI and others. The substantive issue raised by the petitioner was whether a popular initiative for the amendment of the Constitution of Kenya can be commenced by state actors, in particular the President of the Republic of Kenya. The petitioner further argued that a popular initiative in the amendment of the Constitution cannot be commenced and undertaken without a legal framework for the same. The petitioner sought the following reliefs. A declaration that the Constitution of Kenya Amendment Bill 2020 was not a popular initiative towards the amendment of the Constitution of Kenya. B, a declaration that there is no legal framework to undertake an amendment by way of a popular initiative, to wit, collection of signatures and their verification and conduct of a referendum. And C, a declaration that county assemblies have the power to amend the amendment bill, do not have the power to amend the amendment bill. Number 4, petition E401 of 2020, 254 Hope versus the National Executive of the Republic of Kenya. The petitioner herein urged the court to determine whether the national executive or any state organ or entities can commence a popular initiative for the amendment of the Constitution of Kenya and utilize funds in the initiation and pursuit of the process. It is sought the invalidation of the entire process, resulting in the publication, approval, and passing of the amendment bill. The fifth petition was number E402 of 2020, Justice Juma and Isaac Ogola versus the Attorney General and others. The petitioners raised the question whether the creation of 70 constituencies by the by the promoters in the amendment bill was unconstitutional, since the function of delimitation of the constituencies is vested in the IEBC. They urged the court to declare as unconstitutional and annul the creation of the 70 constituencies in the amendment bill. The sixth petition was number E416 of 2020, Morara Omoke versus Raila Odinga and others. The petitioner raised the following issues. A, whether the Constitution of Kenya Amendment Bill 2020 can be submitted to county assemblies for consideration, tabled in Parliament for passing or rejection, and transmitted to a referendum in the absence of a legal framework for facilitating the same. B, whether the amendment bill can be transmitted to a referendum before a nationwide voter registration exercise. And C, whether the use of public funds by the President and Honorable Raila Odinga in the initiation and facilitation of the process culminating in the tabling of the amendment bill in Parliament is unconstitutional. And D, whether Parliament has power to act upon the amendment bill following the declaration of its unconstitutionality for want of enactment of the 2/3 gender laws and the advisory opinion by the Chief Justice to the President for its dissolution. The petitioner prayed that the court declares as unconstitutional and invalidates the entire process culminating in the publication of the amendment bill. Petition number 7 was E426 of 2020, Isaac Alucher versus Uhuru Muigai Kenyatta and others. The substantive question raised by the petitioner was whether the President has power to initiate an amendment to the Constitution of Kenya in the manner relating to the amendment bill and to use public funds in such a process. He contended that the steering committee had converted an illegal presidential constitutional change initiative into a popular initiative. He sought a declaration on unconstitutionality and the invalidation of the entire process. Worthy of notice is that this petitioner sought certain declarations against the President in his personal capacity. And the last petition was number number 2 of 2021, Muslims for Human Rights, Muhuri versus the Independent and Electoral Boundaries Commission and others. The main contention by the petitioner was that the IEBC cannot undertake verification of signatures and registered voters without an enabling legal framework in place, and sought a declaration to that effect. I'll now summarize the responses to these petitions. The Attorney General filed grounds of opposition, raising a total of 12 grounds, which I shall summarize as follows. He stated that a declaration that the Constitution, the provisions founded under Article 255(1) of the Constitution forms the basic structure, entrenchment clauses, and eternity provisions of the Kenya Constitution and cannot be amended under Article 256 of the Constitution or through a popular initiative under Article 257 of the Constitution, would be against the express provisions of the Constitution, including Article 255(1), which will have been rendered odious. He added that the petition did not meet the established legal threshold of justiciability for want of ripeness, that the interpretation propounded by the petitioner runs contrary to the constitutionally prescribed purpose mode of interpretation by negating express purposes of Articles 255, 256, and 257 of the Constitution, and that any comparative analysis of foreign jurisprudence could not be used to either contradict or supplement the text of the Constitution of Kenya, that the petitioners were invoking an advisory opinion jurisdiction which the High Court cannot give. The Speaker of the National Assembly, who was the second respondent, raised 9 grounds of opposition. He concurred with the arguments advanced by the Attorney General with regard to justiciability and ripeness. In addition, the Speaker of the National Assembly contended that the petitioners were preempting how the National Assembly would exercise its mandate with respect to the amendment bill, and that the issues advanced could have been tabled before Parliament during public participation exercise as envisaged under the Constitution of Kenya 2010 and the standing orders of the House. The second respondent further argued that the High Court lacked jurisdiction to intervene in active parliamentary processes, and therefore any challenges to the amendment bill had to await the completion of the legislative process before the jurisdiction of the courts can be invoked to challenge the bill. The Speaker of the Senate, who was the third respondent, also filed grounds of opposition, raising 8 grounds. He reiterated the grounds argued by the Attorney General and the Speaker of the National Assembly. He stated that the people of Kenya have the sovereign right to amend the Constitution in the manner prescribed under Articles 256 and 257 of the Constitution. On their part, the BBI Secretariat and Honorable Raila Odinga filed consolidated grounds of opposition, raising 10 grounds, most of which were a replica of the grounds raised by the first, second, and third respondents. They also filed an affidavit that was sworn by Mr. Dennis Waweru, who stated that he was one of the co-chairpersons of the BBI Secretariat and its co-chairman was Honorable Junet Mohammed, that the Building Bridges Initiative was created and mandated with the task of initiating a constitutional amendment process and unifying Kenya, among other functions. Mr. Waweru deposed that Article 1 of the Constitution of Kenya 2010 vests sovereign power to the people of Kenya, and such power is to be exercised only in accordance with the Constitution of Kenya 2010, that the Constitution is not a rigid document, and pursuant to Articles 255, 256, and 257, it can be amended as provided for in the said provisions, that if the framers of the Constitution did not intend that the Constitution be amended, nothing would have barred them from having such an express provision included therein. Regarding the doctrines and theories of basic structure, constitutional entrenchment clauses, and unamendable constitutional provisions as proposed by the petitioners, Mr. Waweru stated that they were mere theories and hypotheses only applicable in different jurisdictions and relevant depending on the special circumstances of each jurisdiction. The IEBC contended that in the exercise of its powers under Article 257, it enjoys constitutional and administrative, decisional, and financial independence, that it carried out its constitutional mandate of verifying that the constitutional amendment initiative was supported by at least 1 million registered voters, that it was erroneous for the petitioners to argue that there was no legal framework for verification of registered voters, as the provisions of Article 257 made it possible for the actors to know their obligations, and therefore there was no basis of making any finding against it. Making any finding against it. In respect of the petition by Mr. Isaac Alucher challenging capacity of the President to initiate a popular initiative for amendment of the Constitution, the President did not respond to the petition at all. However, the Attorney General filed grounds of objection, stating in the earlier that the President Uhuru Muigai Kenyatta cannot be sued in his personal capacity for any acts done during the pendency of his presidency, that the issue of constitutionality of the president's functions is res judicata, and that monies expended on the president's constitutional functions could only be audited by the Auditor General, the court could not be involved in such an issue. Having perused lengthy affidavits, written submissions, copious authorities, as well as oral submissions by counsel, the High Court made the following declarations. A, that the basic structure doctrine is applicable in Kenya. B, that the basic structure doctrine limits the amendment power set out in Articles 255 to 257 of the Constitution. In particular, the basic structure doctrine limits the power to amend the basic structure of the Constitution and the eternity clauses. C, that the basic structure of the Constitution and the eternity clauses can only be amended through the primary constituent power, which must include 4 sequential processes, namely civic education, public participation and collation of views, constituent assembly debate, and ultimately a referendum. 2, a declaration is hereby made that civil court proceedings can be instituted against the president or a person performing the functions of the office of president during the tenure of office in respect of anything done or not done contrary to the Constitution. 3, a declaration is hereby made that the president does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 or through a popular initiative under Article 257 of the Constitution. 4, a declaration is hereby made that the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report established by the President via Kenya Gazette Notice number 264 of 3rd January 2020 and published in a special issue of the Kenya Gazette on 10th of January 2020 is an unconstitutional and unlawful entity. Number 5, a declaration is hereby made that being an unconstitutional and unlawful entity, the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report has no legal capacity to initiate any action towards promoting constitutional changes under Article 257 of the Constitution. Number 5, number 6, a declaration is hereby made that the entire BBI process culminating with the launch of the Constitution of Kenya Amendment Bill 2020 was done unconstitutionally and in usurpation of the people's exercise of sovereign power. Number 7, a declaration is hereby made that Mr. Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution and specifically Article 73(1)(a)(1) by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. Number 8, a declaration is hereby made that the entire unconstitutional constitutional change process promoted by the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report is unconstitutional, null and void. Number 9, a declaration is hereby made that the Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum before the Independent Electoral and Boundaries Commission carries out nationwide voter registration. Number 10, a declaration is hereby made that the Independent Electoral and Boundaries Commission does not have quorum stipulated by Section 8 of the IEBC Act, as read with Paragraph 5 of the second schedule to the Act, for purposes of carrying out its business relating to the conduct of the proposed referendum, including the verification of signatures in support of the Constitution of Kenya Amendment Bill under Article 257(4) of the Constitution, submitted by the Building Bridges Secretariat. Number 11, a declaration is hereby made that at the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was no legislation governing the collection, presentation, and verification of signatures, nor a legal framework to govern the conduct of referenda. Number 12, a declaration is hereby made that the absence of a legislation or legal framework to govern the collection, presentation, and the verification of signatures and the conduct of referenda in the circumstances of this case renders the attempt to amend the Constitution of Kenya through the Constitution of Kenya Amendment Bill 2020 flawed. Number 13, a declaration is hereby made that county assemblies and parliament cannot, as part of their constitutional mandate, to consider a Constitution of Kenya Amendment Bill initiated through a popular initiative under Article 257 of the Constitution, change the contents of such a bill. Number 14, a declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it proposed to predetermine the allocation of 70 constituencies, is unconstitutional. Number 15, a declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it proposed to direct the Independent Electoral and Boundaries Commission on its function of constituency delimitation, is unconstitutional. Number 16, a declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it proposed to have determined by delimitation the number of constituencies and apportionment within the counties, is unconstitutional for want of public participation. Number 17, a declaration is hereby made that administrative procedures for the verification of signatures in support of constitutional amendment referendum made by the Independent Electoral and Boundaries Commission are illegal, null and void because they were made without quorum, in the absence of legal authority, and in violation of Article 94 of the Constitution and Sections 5, 6, and 11 of the Statutory Instruments Act 2013. Number 18, a declaration is hereby made that Article 257.10 of the Constitution requires all the specific proposed amendments to the Constitution be submitted as separate and distinct referendum questions to the people. Number 19, a permanent injunction be and is hereby issued restraining the Independent Electoral and Boundaries Commission from undertaking any processes required under Article 257.4 and 5 in respect of the Constitution of Kenya Amendment Bill 2020. Number 20, the prayer for an order that Mr. Uhuru Muigai Kenyatta makes good public funds used in the unconstitutional constitutional change process promoted by the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report established by Mr. Uhuru Muigai Kenyatta is declined for reasons that have been given. Number 21, the prayer for the orders that the Honorable Attorney General to ensure that other public officers who have directed or authorized the use of public funds in the unconstitutional constitutional change process promoted by the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report make good the said funds is declined for the reasons that have been given. 22, the rest of the reliefs in the consolidated petitions not specifically granted are deemed to have been declined, and on course, this being a public interest matter, parties shall bear their own course. Those were the orders that were made by the High Court, from which the 4 appeals that I read earlier were raised. The IEBC, in its memorandum of appeal, raised 12 grounds of appeal, which I will summarize as hereunder, that the learned judges of the High Court erred in law in finding that the appellant lacks the requisite quorum for purposes of carrying out its constitutional and statutory mandate in relation to the intended appeal in the interpretation of the role of the appellant to verify that the initiative is supported by at least 1 million registered voters under Articles 257(4) of the Constitution, and instead misconstrued the provision to mean verification of signatures. In finding that the provisions of Article 257(4) require a special framework for verification of signatures. In finding that the administrative measures put in place by the appellant to verify that the constitutional review initiative is supported by at least 1 million registered voters are invalid. The IEBC also faulted the learned judges for finding that the appellant ought to have carried out a nationwide voter registration exercise for the purpose of the intended referendum, for misconstruing the process of certification of the register of voters under Section 6 and 6A of the Elections Act with the requirements for continuous voter registration under Section 5 of the Elections Act, for finding that the appellant had an obligation to ensure that the promoters of the bill had complied with the requirements, public participation before transmitting the amendment bill to the county assemblies. And the IEBC further faulted the learned judges of the High Court for misapprehending the place of public participation in relation to constitutional review process by way of popular initiative, for failing to take note of its jurisdictional scope, for delivering a judgment that is internally incoherent, contradictory, and inconsistent, for granting orders which threatened the usurpation of the functional independence of the appellant, and for failing to appreciate that the evidential threshold for granting the declaratory reliefs had not been satisfied by the petitioners, and consequently arriving at the wrong conclusions. In Civil Appeal number 292 of 2021, this is the Building Bridges to United Kenya National Executive and another versus David D. and others. The two joint appellants, through Paul Mwangi and Company advocates, raised a total of 19 grounds. I'll just summarize a few of them. In summary, they faulted the learned judges for misapprehending the factual matrix relevant to the constitutional amendment initiative, for finding that the basic structure, eternity clauses, and unamendability doctrines are applicable under the Constitution of Kenya 2020, for introducing an extraneous, mandatory, and exclusive four-sequence process unknown under the Constitution of Kenya 2020, for imposing on the promoters of the amendment bill obligation to conduct nationwide public participation exercise prior to collection of signatures in support of the constitutional amendment initiative, for elevating the provisions of the Independent Electoral Boundaries Commission Act above Article 250 as read with Article 2 sub-Article 4 of the Constitution, and for misapprehending Article 257(4) and thereby unconstitutionally and unlawfully imposing a non-existent duty and or criteria for the verification of signatures. There are several other grounds that I will not read. In Civil Appeal number 293 of 2021, the Attorney General versus David D. and others, in his memorandum of appeal, the Attorney General raised 31 grounds, and I'll pick a few of them, that the learned judges of the High Court erred in law by finding that the basic structure doctrine applies to Kenya, for holding that the basic structure of the Constitution can only be amended through the exercise of the sovereign power of the people in the exercise of their primary constituent power, and not as contemplated under Articles 255, 256, and 257 of the Constitution, by finding that certain provisions of the Constitution are insulated from amendments and thereby classifying them as eternity clauses, by admitting and vividly relying on submissions of purported amicus curiae that were partisan, by holding that the amendment bill was not in tandem with an amendment of the Constitution by popular initiative as provided under Article 257 of the Constitution, in misinterpreting the role of the President and the Executive in the process in the process leading to the amendment bill, in holding that the power to amend the Constitution through the popular initiative route is reserved for private citizens, by misinterpreting Article 257 with regard to the persons or entities that can promote amendments to the Constitution, and holding that the BBI National Secretariat could not promote a constitutional amendment, by holding that the BBI process was not in compliance with Articles 10 and 33 of the Constitution, and in failing to appreciate that the amendment bill was subjected to all processes and motions contemplated under Article 257 of the Constitution. Civil Appeal number E294 of 2021, Uhuru Muigai Kenyatta versus David Ndii and 82 others. The appellant, through Mr. Waweru Gatonyi and Company, raised 17 grounds of appeal, and I'll summarize some of them. He contended that the learned judges erred in law and violated or acted contrary to the rules of natural justice by making a decision adversely affecting the appellant and without hearing him, contrary to the provisions of Articles 27, 50, and 159 of the Constitution, by failing to find that the respondents, as petitioners in petition number E426 of 2020, having joined the appellant as a party to the petition, elected not to serve the said petition on the appellant, and further elected to abandon the suit or further proceedings against the appellant in the, I will take that again. Having joined the appellant as a party to the petition, he elected not to serve the said petition on the appellant, and further elected to abandon the suit altogether. In finding that there was a preliminary issue to be determined as to whether the appellant could be sued in his personal capacity and not as the President of the Republic of Kenya, in spite of the fact that the appellant was not a party to the proceedings before the court at the election of the petitioners. In finding that the appellant neither entered appearance in the proceedings nor filed any grounds of objection or a replying affidavit, and in proceeding to hear and determine issues that had already been heard and determined by a competent court of concurrent jurisdiction in the matter of Third Way Alliance Kenya and another versus the head of the public service, Joseph Kinyua, and 2 others, and Martin Kimani and 15 others in 2020 EKLR. The appellant further stated that the learned judges erred in making a declaration that he had contravened Chapter 6 of the Constitution by initiating and promoting constitutional amendment process under Article 257 by failing to by failing to appreciate the scope and extent of the constitutional doctrine of presidential immunity granted by Article 143 in light of the constitutional mandate and the obligations imposed on the office of the President by Articles 131 and 132 of the Constitution. In finding the appellant acting as the President of the Republic of Kenya can be sued in a civil court in his personal capacity during his tenure of office, and by failing to adopt a holistic and contextual interpretation of the constitutional provisions regarding the powers and exercise of presidential authority to meet our constitutional aspirations and values. There were also 3 cross appeals that were filed by the 15th respondent, that is the Kenya National Union of Nurses, the 72nd respondent, that is 254 Hope, and the 76th respondent, Mr. Omurara Omoke. The 15th respondent's cross appeal was premised on 6 grounds, and I'll briefly state them. A, that the learned judges of the High Court erred in 1, ignoring, misapprehending, and misconstruing the doctrine of stare decisis and the stability of the common law. B, in failing to appreciate the petitioner's claim before the trial court on abuse of power, lack of public participation, and breach of legitimate expectation by the BBI task force as against the 15th respondent. C, in finding that the 15th respondent's petition for an independent health service commission was unmerited and could not be admitted for inclusion as a constitutional amendment. D, in failing to take judicial notice of the state of health care in the Republic of Kenya. E, in failing to consider and understand the claim before them and the written and oral arguments in support. F, in dismissing the claim before them after holding a contra review that the respondents in the petition had produced no evidence that there were contrary views to its proposals on constitutional amendments that were adopted in the first BBI report, and which recommendations were illegally left out of the Constitution Amendment Bill. The 72nd respondent, that is 254 Hope, raised 4 grounds of appeal, stating that the learned judges erred in failing to find that where the national executive or any of its task forces makes proposals, including legislative proposals and proposals to amend the Constitution, such proposals are subject to Article 47 of the Constitution. 2, in failing to find that the proposals to amend the Constitution for the failure to meet the threshold of rationality, justifiable reasons for the amendments connected to the stated purpose of the amendments and unreasonableness. 3, in ignoring that when the national executive or any government agency proposes to amend the Constitution, it is subject to a culture of justification through cogent and constitutionally sanctioned reasons in accordance with the Fair Administrative Actions Act. And lastly, in failing to find that there was a violation or at least a threatened violation of the prudent use of public resources, including human resources and funds, when the national executive initiated the amendments of the Constitution. The 76th respondent challenged parts of the decision of the High Court by raising the following grounds of appeal. A, that the learned judges erred in law by declining the prayer for an order that President Uhuru Muigai Kenyatta makes good public funds used in the unconstitutional constitutional change process promoted by him through the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report, despite making the findings that he had no constitutional mandate to initiate constitutional amendment through popular initiative, and that he violated the provisions of Chapter 6 of the Constitution. B, by declining to order the Auditor General to establish the amount of public funds utilized in the promotion of the Constitution of Kenya Amendment Bill 2020. C, by declining to order President Uhuru Kenyatta, Honorable Raila Odinga, and the BBI Steering Committee to publish or cause to be published details of the budget and public funds allocated and utilized in promoting the impugned bill. D, by omitting to make a finding that the illegal authorization or use of public funds to initiate and promote the impugned bill by the President in the midst of the COVID-19 pandemic contravened Articles 10 and 201 of the Constitution. E, by omitting to take judicial notice of the huge amount of public funds, including a 4 billion car grant to MCAs who had assisted the President in promoting the Constitution amendment through the Building Bridges initiative, and that the surge in the incidence of COVID-19 associated with political rallies led by President Uhuru Muigai Kenyatta and the Honorable Raila Odinga to popularize the impugned bill has had an adverse effect on the people's right to the highest attainable standards of health, and that in view of the said issues, the prioritization of the constitutional amendments through the impugned bill was in violation of the state's obligations under Article 43 of the Constitution. F, by omitting to declare sections 32, 33, 37B, 39, 41, and 44 of the impugned bill unconstitutional. G, by declining to find and hold that the Parliament had no legal or constitutional capacity to debate and or approve the impugned bill in view of the advice of the Chief Justice, retired David Maraga, to President Uhuru Muigai Kenyatta to dissolve Parliament. And G, by relying on ongoing frivolous litigation as a basis for declining to order President Uhuru Muigai Kenyatta to dissolve Parliament in accordance with the advice of the Chief Justice, retired David Maraga. Thank you. I'll stop at that, and Justice Tuyot shall now begin to read